So good afternoon, everyone. Thank you so much for inviting me to this wonderful demonstration of our students' work. I didn't realize we had a vibrant law and philosophy, and as a recovering philosophy graduate student, it's good to come back. I'm a recovering philosophy graduate student. So I am here to introduce Professor Kennedy. I am a student of Professor Kennedy's, as Professor McCartan is. We're both students of Professor Kennedy's, I believe, and probably other people in the law school as well are Professor Kennedy's students. And I'm going to tell you, so I always do this thing when I do an introduction for someone who's dear to me who comes to Tulane. I'm going to tell you how awesome their CV is, and then I'm going to tell you how awesome they are as human beings based on my interaction. I'll tell you what's not on the CV as well. So Professor Kennedy is one of the leading luminaries of Harvard Law School. He's a member of the American Law Institution and the American Philosophical Association, a graduate of Princeton, Oxford, and Yale. Professor Kennedy was a Supreme Court clerk for Justice Marshall, right? And Professor Kennedy told me that Justice Marshall used to call them knuckleheads. And one of the knuckleheads that Professor Kennedy helped facilitate into a clerkship with Professor Marshall, and this is documented in the New York Times, I'm not telling tales out of school, was Justice Kagan, right? So Justice Kagan is also a student of Professor Kennedy's. He is the author of 164 publications, 164, and probably more since Harvard, that was from the Harvard website. 7 books, including the 1998 Robert F. Kennedy award-winning book, Race, Crime, and Law. He is a public intellectual extraordinaire and an iconoclastic thinker and truth teller. He asks hard questions and he publishes thought pieces in international magazines and newspapers. Here are some of them: the New York Times, the Washington Post, The Nation, Dissent, American Prospect, the Chronicle of Higher Education, and Harper's Bazaar. And so this is some of what's on the CV. But I'm a student of Randall Kennedy's. RK is what my friends used to call it. My friends and I, when we talk about our class excitedly at night, we'd say, "Can you believe RK said that?" What do you say? Well, I'm going to defend RK. This is Professor RK, where we would talk in our BS sessions late into the night. But we did, right? We did talk about him lovingly, but also sometimes, questioningly, right? Because he asks hard questions. I had the privilege to be his RA one summer and I was in his class. So I'm going to tell you what's not on his CV. First, Professor Kennedy is a master teacher. His classes are life-changing. I was transformed to know him. I think all my friends in our IR. If we get together and we have drinks on the coast, my law school friends and I, we talk about Randall Kennedy. His ears are burning. We will talk fondly about his classes. We will talk about his scholarship. We will talk about him, right? 20 some years out, these lady law professors who are mamas, some of us law professors in our own right, are still invoking the spirit of Randall Kennedy in our conversations. Other thing to know about him, he is wise and he will invoke the wisdom of the ancestors for you. My classmates and I were often regaled with stories of Big Mama. He would talk about Big Mama's wisdom in our classes. She who lived in South Carolina, it was wonderful to have Big Mama's spirit in the classroom, right? So Oxford, Princeton, Yale, this is where he gets his wisdom. Also, Big Mama, right? He is an excellent, kind mentor. This famous world-class intellectual found a time to call the Harvard Law School faculty when a certain young African-American woman was seeking to obtain employment here. So he was a wonderful mentor, and I'm very grateful for him. He is also funny, right? He has a wonderful sense of humor, and my classmates and I would be regaled by his wit. We laughed in class. We definitely laughed in class. And this is something that I think is very special among Harvard faculty. And all my Harvard teachers were wonderful, right? They're all wonderful in different ways. But Professor Kennedy is curious. He maintains a joyful, curious, questioning nature despite his vast experience, his 164 publications. He asks hard questions and he asks questions that matter. And he doesn't have an in what the answer is, right? So many law professors never leave behind the role of advocate. Oftentimes when we ask hard questions, and I'm one of these people, I'm not going to lie to you, right? I want to put my thumb on the scale for a certain answer. Randall Kennedy asks questions bravely and from the curiosity of the question asking and the truth seeking. And it is a wonderful quality to have in a teacher and a mentor and a professor. And finally, he is an unmatched storyteller. And so I'm so excited for what he will bring to us today. And I'm so grateful he is here to teach us today, to share his wisdom, and to encourage our own curiosity. So I'm curious about what he's saying. So without ado, I will turn the stage over to my beloved teacher, Professor Kennedy.
Very nice. What a moving introduction. Thank you so much for it. Very gracious, and I really appreciate the generosity. You know, you were indeed a research assistant, and the assignment, you might not recall, but I recall. The assignment was, well, there were several assignments, but there was one in particular. I was interested in the way in which other groups had interacted with African Americans in various racial conflicts. So how did Latinos, how did Asian Americans, how did Native Americans deal with African Americans in various racial struggles? And you wrote a very comprehensive bibliographical essay, and I still have it, and I still use it. I'm very appreciative of that. You mentioned in your introduction that I clerked for Thurgood Marshall, and indeed I did, and it was one of the great privileges of my life. It was one of the great highlights of my life. I also clerked for J. Skelly Wright. And this morning when I took a run across the street in Audubon Park, I made it my business to go to the Loyola Law School to see the statue that Loyola put up for J. Skelly Wright. And I'm here, you know, I'm here in New Orleans. It was here in New Orleans that this was the first major city in the South, in the deep South, to have a United States District Judge enforce Brown versus Board of Education, Bush versus Orleans Parish. And J. Skelly Wright was behind that. The plaintiffs in that case were backed up by a wonderful New Orleans attorney, A.P. Turow. I was very happy. I don't know how I came across this. I see that there's a street here named after A.P. Turow, and there should be. There should be. A.P. Turow was a great civil rights attorney, fought many struggles here in Louisiana. So I'm very appreciative of your comments, and I'm very appreciative of being here. By the way, I thought that the presentations were they were excellent presentations. And the whole project, the whole idea of students giving reports on their work, what a good idea. It's an excellent idea, and there should be more of it. I'll be taking the idea back to my spot. And it's a wonderful idea. I mean, for one thing, just to, you know, the exercise of getting up and, you know, talking to people about what you're doing, that itself is a good exercise. Not to mention, you know, getting tips from people, that's good, that's a useful thing, but just having to get up and, stand and deliver for a few minutes and just tell people what you're up to, that's a useful enterprise. That's the enterprise in which I'm engaged here. So I'm going to spend a few minutes basically telling you about an enterprise on which I've been working. I've been working on this for a long time. I've been working on a book for about 9 years. It's tentatively entitled From Protest to Law: Triumphs and Defeats in Struggles for Racial Justice, 1950 to 1970. That's the provisional title of this book. My editor at Knopf thinks that that title is boring. Does, and they're interested in that because it's a trade publisher. I mean, basically, they want to make money, and so they want, they're interested in titles that'll bring people to a book project and prompt people to buy the book. I told them, I said, well, I've been working on this and I've been thinking about titles, and if you can come up with something better, I'm all ears. That goes for this audience too. My email address is rkennedy@law.harvard.edu. If you come up with a better idea, believe me, I'm all ears for it. Let me tell you a little bit about this book. So, this is a book that tries to answer the following question: how did protests against racial injustice in the mid-20th century change American law? That is the question. And let me just say a bit about the highlights of what I've done thus far. And I suppose that I think that I'm about 80% done. This is going to be by far the longest book that I've ever written. I suspect that when all is said and done, this book will be about 800 pages. It's a long book. But here, again, from protests to law, triumphs and defeats in struggles for racial justice. So let's talk about triumphs first. In terms of substantive race relations law, there was lots going on, but just for the purpose of our setting, I don't want to go on too long. But there would be three. I'd say that there would be the three most important advances, the three most important changes in the substantive law of race relations in this period between 1950 and 1970. There'd be three. Number one, the invalidation of de jure segregation. That would be number one. And the high points of, the highlights of that struggle, and it was a tremendous struggle that involved practically every imaginable activity in which the government was involved, whether we're talking about schools, whether we're talking about public cemeteries, whether we're talking about libraries, whether we're talking about the military, the invalidation of de jure segregation. And this was an enterprise in which probably the most important intervention would have been judicial. Brown versus Board of Education, May 17th, 1954. Now, In legal academia, there's been a lot of struggle over Brown versus Board of Education. And I have colleagues who have questioned the significance of Brown versus Board of Education. One of my colleagues, a friend, sometimes an adversary, was Derek Bell, very distinguished legal academic, person who fought the good fight for Brown versus Board of Education. But ultimately, near the end of his career, suggested that Brown versus Board of Education's way oversold, and maybe, I think he might have been saying this to be provocative, but in any event, sort of tested the balloon, sent up a test balloon. Maybe it would have been better had the court reached a different conclusion. So you have Derek Bell. I have another colleague, Michael Klarman, who very distinguished legal historian, but who has suggested that Brown versus Board of Education on its own wasn't so important. His suggestion is that Brown versus Board of Education triggered a backlash against it, and that it was the backlash against it that really was important and was the predicate for progress on the racial front. I think that's profoundly mistaken. Brown versus Board of Education was announced on May 17th, 1954. On May 16th, 1954, the day before Brown versus Board of Education was announced, as a matter of federal constitutional law, it was legitimate. It was legitimate for states with respect to public education, K through 12, it was legitimate for a state like my home state of South Carolina. It was legitimate for a state to say, the colored people are educated over here and the white people are educated over here. And we can mandate that and we can enforce that. That was the state of the law on May 16th, 1954. May 17th, 1954, the Supreme Court announces Brown versus Board of Education. What does that mean? That means that it is no longer constitutionally legitimate for governments to separate people on a racial basis in schooling. I say Brown versus Board of Education, I make reference to the states. Of course, Brown versus Board of Education had a companion case, Bowling versus Sharp, in which the Supreme Court said the federal government can't separate people on a racial basis in schooling either. That was hugely important. The needle of legitimacy was moved by Brown versus Board of Education. Now, it's true that in many places in the Deep South, nothing much changed on the ground for the next decade. That's absolutely true. Absolutely true. But the needle of legitimacy had changed. So one of my favorite cases, one of the cases that I spent a lot of time on in my book, is a case called Meredith versus Fair. James Meredith seeking entrance into the University of Mississippi. Now, in the early 1960s. Brown versus Board of Education had been decided by the time that James Meredith seeks entry into Ole Miss. He applies. What do the officials at Ole Miss say in the face of James Meredith's application? They make up all sorts of stupid, crazy, dishonest reasons for trying to exclude James Meredith. They could not do in 1961 what officials in Texas had done when Heman Sweat applied. When Heman Sweat, black mail carrier, when he applied to the University of Texas, the University of Texas official said, you know what? You've got a really good record. And we would let you in, but for the fact that you're black. They said that. They didn't beat around the bush. They said it. They were perfectly upfront. They were perfectly honest. That was in 1947. When James Meredith applied, they could no longer be honest. They had to lie. And they were caught out by their lies. They were caught out by their lies. Good Louisiana judge was actually sort of funny in the way that he sort of was facetious. The great John Minor Wisdom talked about how ridiculous the officials at Ole Miss were in saying that they had not excluded James Meredith on a racial basis. Judge Wisdom said, gosh, a lot of people in Mississippi are going to be disappointed to hear that. It's ridiculous. The officials in Mississippi had to lie because of Brown versus Board of Education. They could no longer be honest. Well, that was important, making people lie. Okay, so number one, the invalidation of de jure segregation and all that it meant. And behind Brown versus Board of Education were 100 cases, more than 100, several hundred cases, including, of course, the most aptly titled case in all of American constitutional law, Loving versus Virginia, in which finally in 1967, the Supreme Court of the United States strikes down all remaining statutes prohibiting marriage across the race line. It was that was the last of the segregation cases, really. So that was one of the triumphs. Second, the attack on so-called private racial discrimination. So, in 1961, in 1962, and 1963, it was not illegal as a matter of federal law for someone to say, put up a sign. I'm looking for electricians. I'm looking for white electricians. Negroes need not apply. That was not against the law. Negroes need not apply. That was not against the law. It wasn't even a big deal. Negroes need not apply. Or let's suppose that you owned a restaurant or a hotel. The hotel is open. Our restaurant is, open. Our hotel is open for white people. Now you other people, y'all can go around back maybe, or just don't come here. God bless you, but no, we're not going to deal with you. That was perfectly legal. And by the way, that wasn't so long ago. And sometimes in my dealings with students, I talk about the early 1960s, and they look at me as if I'm talking about, when the dinosaur roamed. Oh, no, what when I remember that. Now I'm old, but I'm not that old. I'm speaking to you. I remember that. I remember going in Columbia, South Carolina to see The Nutty Professor with Jerry Lewis as the Nutty Professor. and, going in the side, sitting in the balcony where the Black people sat. Wasn't that long ago? That is struck down. These are private parties. It's not the government we're talking about. These are private parties. The private owner of a hotel, private owner of a restaurant, private employer, private union. Unions went in on this too. Lawful. What was the intervention as a matter of federal law that limits the ability of people to engage in so-called private racial discrimination? Title II of the 1964 Civil Rights Act. Title II. The title that deals with public accommodations. And, that was the most controversial part of the 1964 Civil Rights Act. It's sort of an interesting thing. Who talks about public accommodations now? No one. No one. You could, in a weekend, you could master the law regarding public accommodations. It's a sort of a striking thing. When Title II was passed, very effective. It was very, was there some resistance? Yeah, there was some resistance, but not a whole lot. Didn't last very long. But Title II of the 1964 Civil Rights Act, and then of course Title VII of the 1964 Civil Rights Act involving employment. Now, there was a lot of resistance with respect to employment and continues to this day. But Title II, Title VII, private, attacks on private racial discrimination in various markets, in public accommodations, the employment market, 1968 Open Housing Act. So again, another iteration, another market in the private housing market. So that'd be the second big development. Third big development would be the attack on racial disfranchisement. And there, the big advance would be the Voting Rights Act of 1965. Voting Rights Act of 1965 was really an attack on the various frauds, the chicanery, in some instances, just the sheer terrorism that kept Black people from voting in parts of the Deep South. So those would be the three big achievements. There were others, but let's leave that alone for now. Let me add one other thing. On the achievement side, much of my book will deal with developments in substantive race relations law, but much of the book will also deal with civil liberties, because behind each of those changes in substantive civil rights law was protest. People had to protest. And when people protested, there was an effort to repress the protest. And when the repression came, people had to fought back, often fought back in court, fought back in other ways too, but the courts were the main way in which people fought repression and generated case law, civil liberties case law. This turns out 1950 to 1970 turned out to be the glory time for civil liberties in the United States. Let me give you a couple of examples. So, the National Association for the Advancement of Colored People was the main organization supporting the lawyers attacking de jure segregation. Nowadays, people, it's no big, do you belong to the NAACP? Sure, people stickers on their cards. No, not even a big thing. In fact, it's a yawn. Belong to the NAACP. Well, big deal. No big thing. Well, you know, it was a big thing if you were living in Alabama to be a member of the NAACP or in the mid-1950s. In fact, it was such a big thing that it was a secret. You didn't go talking about you're a member of the, no. You kept that under wraps. In the 1950s, in the aftermath of Brown versus Board of Education, a number of states got together and paid the NAACP a supreme compliment. The attorneys generals of these states said, you know what, we got to do something about this NAACP. They have been all too effective. But we've got to crush them. And they attempted to do just that. In Alabama, they said, well, the NAACP has failed to abide by our rules involving out-of-state corporations, and therefore we're going to seek an injunction to prevent them from acting. And furthermore, we want their membership lists. State of Alabama demanded the membership lists of the NAACP. Why do you think they wanted the membership lists of the NAACP? Do you think it had anything to do with some bona fide investigation of the NAACP? Of course not. What they wanted was the membership list for two reasons. One, they wanted the membership list so they could then leak the membership list to segregationist newspapers that would then proceed to list all the people in the NAACP. That's what they wanted to do so they could punish any members of the NAACP. And second of all, they wanted to list the membership list to make anybody afraid of becoming a member of the NAACP. So it was a very important, this was a straight out attack on the NAACP. Let me drop a little footnote here. This posed a real dilemma for the NAACP. What do we do? Local judge, thoroughgoing segregationist judge, Walter B. Jones, told the NAACP, give me that list or I'm going to fine the NAACP. The NAACP had to make up 's mind as to what they were going to do. Their lead lawyer, Mr. Civil Rights, their great lawyer, person whom I revere, Thurgood Marshall, urged the NAACP to give up the list. His principal deputy, Robert Carter, reached a different conclusion and said his advice was, don't give up the list. And the NAACP Board of Directors went with Carter's advice and fought it. I think that's a really interesting thing. I think it's interesting that the NAACP actually went with the advice of Robert Carter, and Carter's advice ultimately prevails. The NAACP fights it. They ultimately win. This is very important. The whole doctrine of organizational privacy as a constitutional doctrine begins with NAACP versus Alabama. Of all sorts of ideological dispositions, from the way to the left to way to the right, depend upon this. Not thinking about it. Don't even think about it. NAACP versus Alabama. Tremendous step forward with respect to the question of civil liberties. Let me give you another example. Every day, people, they don't, you don't have to be in law school. People sort of have intuited the idea that when newspapers or television, the news media, when the news media says something about a public figure, the mayor, the governor, the president, the police chief, I think just regular folks. I mean, if you went down, St. Charles and just, asked regular folks, can newspapers talk about public officials, and are newspapers vulnerable to libel actions if they make mistakes? I think a lot of just regular folks would say, nah, just if they just make a mistake, I don't think that public officials can actually sock it to news media. And they'd be right. They weren't right before the early 1960s. They weren't right before 1964. Prior to then, if a newspaper made a mistake with respect to a public official, just the state law of libel would govern. It was not a federal constitutional matter. What happens is in the early 1960s, the CBS News and the New York Times and various magazines, they send people to the Deep South, what's going on. And the segregationists, the white supremacist forces, don't like their repression, their oppression being publicized. So they try to chase the news media away. And what do? They try to chase the news media away by using the law of libel. New York Times, you said this about, the chief of police, and this is, you made an error. The chief of police then sues the New York Times and says, I want $500,000. Local jury says, yeah. The New York Times is on the hook for millions of dollars. And the effort was to chase the New York Times and other publications away through the use of libel law. Well, New York Times gets some lawyers and fights this. And the upshot is New York Times versus Sullivan, the constitutionalization of the law of libel, which gives breathing room to news media, which we depend on day by day, not even thinking about it. One other example. This is a sentimental one. I told you I'm from South Carolina. This is an example that comes from Columbia, South Carolina, one of my favorite cases. Edwards versus South Carolina, 1963. Group of students, mainly high school students, Black high school students in Columbia, South Carolina, want to protest. They talk to their ministers about protesting. They go to a Baptist church, they all meet there, and then they march a few blocks to the Columbia State House. And they told the police that they were coming, and they had, everything was fine. They were very disciplined. They go and they march. They march for 45 minutes. They march around the State House, down with segregation, down with segregation. And what happens is a group of white people gather across the street. And more gather, and you can sort of, there's a certain feeling growing. You have the Black people marching, you have the white people don't like the marching. And the police get nervous, and the police tell the students, okay, you've had your say, we want you to stop. And the young ministers say, no. We're not stopping. We're not bothering anybody. We're here on the State House grounds. We are not interfering with traffic. We're not interfering with pedestrians. We're going to continue. And the police say, we're going to give you 5 minutes. And if you don't stop, we're going to arrest you. The 5 minutes go by. The police, and by the way, the police were not, these were not brutal police. These were not these were not terrible police. They say, are you going to stop? And the ministers say no. And the police say, okay, we're going to arrest you. And then the students do something that is absolutely, I mean, it's just, the students sink to their knees and pray, and then start singing songs. They start singing Star Spangled Banner. They start singing America. They start singing their church songs. They're being arrested. They're being arrested, and they are singing their songs. This turns out to be very important. This turns out to be very important. The case, they are prosecuted. They're prosecuted for disorderly conduct. They're prosecuted. The South Carolina Supreme Court upholds their prosecutions, upholds their convictions. The case goes to the Supreme Court of the United States. The Supreme Court of the United States reverses in an opinion by Potter Stewart. And the part of the opinion that I always love is the part of the opinion where Potter Stewart says these students were exercising First Amendment rights in their most pristine form. The students had won everybody. The students won over. There was one dissenter. Tom Clark dissented. It was a dissenter, but it was 8-1 opinion, 8-1 decision. I love that case. One of the reasons I love the case is, I knew some of the people that were among that 187. They were older than me, but I knew them. And I also knew their lawyer. Their lawyer was a man by the name of Matthew Perry. Matthew Perry was the Thurgood Marshal of the Palmetto State. If you go to Columbia, South Carolina, to the federal courthouse, you go to the Matthew Perry courthouse. He was the first Black federal judge in the state of South Carolina. If you went on a protest in the 1960s, and I know this because my cousins protested, you made sure that you had the telephone number for the Jenkins Perry law firm. You didn't have anything else. You had that number in your pocket. That's who you were going to call. And one other little footnote. A number of years ago, there was the weekend that the Matthew Perry courthouse was sort of unveiled, the Bar of South Carolina did actually a quite wonderful thing. The Bar of South Carolina put aside 2 days to honor Matthew Perry, and Matthew Perry was still alive. They honored Matthew Perry, and any legal figure of any note in South Carolina was there. All of the living governors were there. I mean, it was like the who's who of the Bar of South Carolina was there. It was very moving. It's very moving. There was a prosecutor. It was amazing. At one of the symposia, there was a prosecutor. Old man raised his hand, was called upon. Took forever for this guy to get up out of his seat. Gets up out of his seat. He turns to Matthew Perry. He says, I was the prosecutor in such and such a case. It was a case in which the judge held you in contempt of court because the judge told you not to raise a certain issue, but you raised that issue in order to protect the record, in order to make the record for appeal. And the judge held you in contempt and you were put in jail. And I just want to tell you, I'm sorry about that. I mean, I thought, oh my God. One other thing from that, the Chief Justice of South Carolina at that moment was a Chief Justice Toll, Toal. I forget her first name. She was the first woman Chief Justice, state of South Carolina. And she got up and gave a talk about what prompted her to want to practice law. And she talked about, she said, the thing that sparked her interest in practicing law was going to see Matthew Perry defend the 187 students. She said that was the beginning. And I thought, oh my goodness. Here you have the first woman Chief Justice of the state of South Carolina talking about how she was inspired to practice law by Matthew Perry. I mean, I thought, this is extraordinary. Some of the triumphs. Were there defeats? Yes. And in fact, I'd say over the last 9 years, the thing that has probably influenced me the most, the biggest change for me, has been on the subject of defeats. Because when I began, I'd say, 9 years ago, the project really was quite triumphalist. It really was. It was quite triumphalist. It had a big smile on it. I mean, it was basic. It was, we shall overcome, and we overcame, and great. Now, as we will see, I'll wind up in a minute. I still take the position that a lot was changed. I take the position that the campaigns of the Second Reconstruction, the campaigns of the Civil Rights Movement were extraordinary, and they did move the needle, and they affected things. But I'd say over the past 9 years, the biggest change in this book has been, at least for me, a recognition of the defeats. So what do I mean by that? Well, I mean a lot of things by that, but just a couple. Let's go through what I just talked about as the victories. Brown versus Board of Education. Victory. It did move the needle of legitimacy. But in large swaths of America, for 10 years, there's an open, totally open defiance of Brown versus Board of Education. Totally open. And the legal system went along with it, including, by the way, the Supreme Court of the United States. One of the mechanisms for defying Brown versus Board of Education was the creation at the local level of pupil placement laws. So, in order to go to school, the idea would be that locality said, okay, you go to the school that, if you want, you go to the school that you've been going to, and if you want to change out of that school, you've got to sign some papers, and you've got to do this, and you got to do that, and you've got to take some tests, and your parents have to be interviewed, and blah, 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 blah. What was behind that? What that was about was, okay, so Black people, y'all start off going to the school that you were going to under segregation. And if you want to do something else, you're going to have to jump through a whole lot of hoops. What, you're in the deep South and you tell Black people you want to go to a different school, but you got to go down to the education department and make a case. Who's going to do? And by the way, were there some people who did it? Yeah, there were some people who did it. And if you failed to dot an I, if you failed to cross a T, your application was thrown out. Supreme Court of the United States upheld school placement laws. Now, I look back, I mean, I think, didn't they know what was up? Yeah, they knew what was up. But Supreme Court, their feeling was, well, we took a big step with Brown versus Board of Education. We've done about as much as we can do for a little while. Maybe they were right. It's not like I'm cussing them out. Maybe they were right. Maybe that was the prudential thing to do. All I say is do recognize the limits, Brown versus Board of Education. There were, it was limited. Example, again, and I feel a little bit embarrassed about this because, I'm the teacher. I'm, teaching classes and, sort of trying to be authoritative. Aaron versus Cooper. Aaron versus Cooper is a very well-known case. That's the Little Rock case. Remember, Aaron versus Cooper, Orville Faubus, the governor of Arkansas, tries to stop the enforcement of Brown versus Board of Education. First, he authorizes the National Guard to exclude the Black students. And then he removes the National Guard and basically allows a mob to exclude the Black folks. So much so that, Dwight Eisenhower, to his credit, Dwight Eisenhower sends in the paratroops. Says to the United States Army marched the Black students in. 9 Black students. By the way, this is a big school. 2,000 people, 2,000 students, all of this, 9 Black students. The Army marches them in. Now, this is often, and for a long time, when you were in class, I bet, Aaron versus Cooper, and the last line, the last thing you learn about Aaron versus Cooper, for years in my class, the last sort of word was, well, thank goodness, Dwight Eisenhower, sent in the troops, and this is the triumph. This is the triumph of law in America. That was the last line. Well, actually, you know what? Nope, I'm sorry. That was good. I'm glad that Dwight Eisenhower, marched the kids in. That wasn't the last. Next year, Orville Faubus closed all of the high schools in Little Rock for a year. For a long time, tell you the truth. I eventually learned it. That's a defeat. And then, of course, in Virginia, Prince Edward County, they closed all the schools for 5 years. 5 years. Those are defeats. I spoke about the 1964 Civil Rights Act. 1964 Civil Rights Act. Title VII. For many years, when I'd be talking about Title VII, I would describe Title VII as a law that prohibited racial discrimination in private employment markets. That's the way I would describe the law. Too broad. No. You go take a look at the Title VII of the 1964 Civil Rights Act. Title VII of the 1964 Civil Rights Act says this act applies to employers with, I believe in 1964, I think was with 25 or more employees. Now, walk down a street and check out what businesses have 25 or more employees. That's a pretty big business. There are a whole lot of businesses that don't have that many people working for them. The law actually, and this was demanded, Everett Dirksen required this for the law to be passed. This was part of the compromise. The law is not as, it's not as broad, it's not as powerful as for many years I had, sort of suggested. Not only that, here's another thing. Title VII of the 1964 Civil Rights Act says, okay, here's what we're going to do. For the first year, first of all, it's not going to be effective at all for a year. Okay, so for 1 year, it's just not effective. So it'll become effective. We'll start making it effective a year from now. And then a year from now, it'll be targeted at employers with 100 or more employees. Then the next year, it'll be 75 or more. Then the next year, it'll be 50 or more. Then it'll become fully effective. That's than the way I think that many people, certainly than the way I thought, well, heck, the Congress passed the Civil Rights Act of 1964. Well, in 1964, things are different. It was a slow rollout. Those are aspects of the story that, at least in my, in my book, I'm going to, sort of emphasize, because I think that they have been really neglected. The triumphs, they were real triumphs, but they were limited. They all had compromises, big compromises. People should know that. The Voting Rights Act of 1965, very important, had, it certainly made a difference with respect to voting, but Voting Rights Act of 1965, it had its limitations too. It was nullified in various ways. There were all sorts of ways in which it was evaded. So that's part of the story that for me has become important. Administration of criminal justice. In our time, we're, the time of Black Lives Matter, the administration of criminal justice. The administration of criminal justice is probably, in many respects, the area that change was most difficult in the Second Reconstruction with respect to the administration of criminal justice. So, for instance, during the period between 1950 to 1970, there were various efforts launched by the NAACP Legal Defense Fund to attack the administration of capital punishment on racial discrimination grounds. Did any of those prevail? Answer, no. It's never prevailed. Hasn't prevailed in our time. There was the case of, juries. Swain versus Alabama, 1965. In 1965, question: can prosecutors use race in excluding potential jurors? You might think, oh, this is an easy one. Come on, this is an easy one. Of course not. you'd be wrong. Supreme Court of the United States, close decision, ruled, Justice White writing the majority. Prosecutors can't use race if they're using race in case after case, time after time, as a basic, a way of barring blacks from the jury. But if it's only a matter of trial tactics, it's only a matter of trial tactics in a particular case, it's no problem with using race, because after all, it may be that the prosecutor wants to select a jury in a certain way in a case in which, excludes black people on Monday, but, maybe trial tactics will lead him to want to exclude white people on Tuesday. It wasn't until 1986 that Swain versus Alabama was finally reversed, Batson versus Kentucky, pursuant to a campaign launched at the Supreme Court by guess who? Mr. Civil Rights Thurgood Marshall. But in 1965, racial discrimination with respect to juries was permitted. One could go on. Defeats in the civil liberties area. Again, here's the place where I really used to emphasize the smiley face with respect to civil liberties. Supreme Court, and part of this was the influence of a wonderful little book by Harry Calvin. Harry Calvin was a distinguished professor at the University of Chicago Law School, and he wrote a little book called The Negro and the First Amendment. And he talked about how providential it was that you had the civil rights movement and them, doing the right thing, and the Supreme Court doing the right thing. And they got together and they created a wonderful, blossoming of civil liberties law. A very happy story, very happy story. And, it's a story that, that I, sort of built, I built upon that. And, it's a story I told for a long time. What does one do, however, about the encroachments on civil liberties that were propelled by local law enforcement and federal law enforcement, mainly the Federal Bureau of Investigation, vis-a-vis surveillance, vis-a-vis dirty tricks, vis-a-vis harassment? During this entire period, J. Edgar Hoover would pick out people and pick out organizations and basically say, off with their heads. Martin Luther King Jr. The FBI was listening on Martin Luther King Jr. The FBI, tried to get Martin Luther King Jr. to commit suicide. They got incriminating, evidence of him and his extramarital affairs and tried to get the man to commit suicide. The Federal Bureau of Investigation was behind, ginning up bad blood between various organizations. It's famous, infamous COINTELPRO program. It was finally found out. The Congress held hearings. We now know about COINTELPRO. I think it's generally disapproved of, but was there ever a reckoning with respect to COINTELPRO? No. That, it seems to me, is a very important part of the story. And it puts a pall over the more sort of enthusiastic, happy story. So those are, so triumphs, defeats. Let me give my bottom line and then let's proceed, but questions, comments, objections. My bottom line is, did this period change things? Yes, this period did change things. What's my basis for saying that? And here I suspect that I'm going to encounter criticism, and I'd like to hear I'd like, if people find this a problem, let me have it. Save me from myself. As I say is, okay, we have to have a baseline. And if you're going to say, if you're going to say that this movement moved things and there was progress, you got to have a baseline. Baseline? I have a baseline. What did racial dissidents ask for in, let's say, 1944? I picked 1944 because in 1944, the University of North Carolina published a book. It was an anthology of writings by the leading Black activist intellectuals of the time. So W.E.B. Du Bois, Mary McLeod Bethune, A. Philip Randall, Black communists. You'd say you had the gamut, the ideological gamut of Black thinking was in what the Negro wants. If you take a look at that book and then you ask, go through the essays, and people, we want this, we want this, we want that. Okay. By 1970, all of the demands on the legal system voiced in this book had been met. Now, does that mean, everything is great by 1970? No, not at all. I mean, for one thing, very important thing, it may very well be, these were people writing in 1944. It may very well be that, their imaginations were limited. They asked for what they thought may be plausible. They might have been afraid to ask for certain things. In fact, the publication was almost squashed because the University of North Carolina Press was scandalized by the fact that all of the people writing demanded an end to segregation. The University of North Carolina Press was surprised by that, and there was a big fight about that as to whether to even publish the volume. But it is meaningful. It is meaningful that in 1944, if you take a look, what do people demand? Desegregation of the armed forces, desegregation of, schools, attacks on so-called private racial discrimination. Then, Harry S. Truman created in 1948, 47, 48, Presidential Task Force, which set forth its own blueprint. By 1970, all of those measures been met. Now, it seems to me that, that's an important, that's important. And that says something. What else would I, again, what else, why else would I say this period marks a real move forward? And in my view, in the, sort of the history of social justice movements, it's quite extraordinary. I'd say, well, the United States of America is not the only country in which there have been, divisions. It's not the only country that's had divisions. A lot of countries have had divisions. A lot of countries have had divisions. Show me an example of a racial minority a long time despised, denigrated racial minority doing what was done between 1950 and 1970. Now, I mean, take a look at Northern Ireland. Take a look at, I don't care where you take a look at. I'd be very interested to know about an analog that outdoes what was done in the United States of America in this period. I think that what was done was really absolutely extraordinary. If one thinks about, the modern world, social change agents all over the world. Dissidents in China sing, "We shall overcome." Dissidents all over the world quote, "Letter from a Birmingham jail." I mean, it's just absolutely extraordinary. And then if one takes a look at, okay, well, the history didn't end in 1970. I mean, after 1970, there were other struggles, right? There were other struggles. There was the women's struggle, the feminist struggle. Take a look at some of the leading feminists and what they said and where they found their voice. Many of them, I found my voice in Mississippi. That's where I said, well, damn, I'm here. Women aren't being given their due. We need to do something. Take a look at gay liberationists. Just go down the roster where they find their voice. I was in Alabama in 1963. I was closeted. And I thought, this isn't right. We need to do something. Take a look at the roster of people who were involved in nuclear disarmament and the peace movement. Over and over and over again. Where did they find their voice? Second Reconstruction, the civil rights movement was the great seedbed of social reform in the latter half of the 20th century. There's no movement, poverty movement, you name it. There is no movement unaffected by the Second Reconstruction. And again, I don't want to, obviously it was limited because, we're in 2023. We're in 2023, and obviously, do we have many race problems in the United States of America? The answer obviously is yes. So obviously the Second Reconstruction wasn't, it had its limits. No two ways about that. We're living with them. We are grappling with those limits. But did things change? I'm going to end my remarks with one case. And here's one thing that, one of the things that I've sort of been on the lookout for, people know a good bit about sort of, the big cases, Brown versus Board of Education, Loving versus Virginia, South Carolina versus Katzenbach. The sit-in cases. They know a lot about, certain, the big cases. I sort of have my eye out for cases that are not so well known. One of my favorite cases is a case called Hamilton versus Alabama. And here's what happened in Hamilton versus Alabama. The case involved the plaintiff, not the plaintiff, she's actually a defendant, she's a criminal defendant. Mary Hamilton was a Black woman from New York City who goes south. She's working for the Congress of Racial Equality, and she is arrested in a demonstration in Alabama. At trial, the solicitor for the state of Alabama says, "Mary, why were you arrested?" And the response he gets is, "My name is Miss Mary Hamilton." The prosecutor responds by saying, "Mary, why were you arrested?" She responds by saying, "I object. You refer to the white witnesses by their proper surnames. My name is Miss Mary Hamilton." The solicitor then turns to the judge and says, "Judge, I want you to instruct this witness to respond. Her name is Mary. And I want an instruction for her to respond." The judge turns to Miss Mary Hamilton and says, "You need to respond, and if you do not respond, I'm going to hold you in criminal contempt of court." This young woman has to make a decision, and she makes it. My name is Miss Mary Hamilton. He sends her to jail. She serves 60 days. Case goes to the Supreme Court of the United States. The Supreme Court of the United States summarily reverses. She's already served the 60 days. Love that case. One of the reasons I love the case is, there's not a whole bunch of legalistic rigmarole. It's so basic. It's so fundamental. This is a person who just demanded equal. You call the white people by their last name, call me by my name. And I'm willing to go to jail behind that. And she does. Now, one of the things that I try to draw out from this, and one of the sub-themes of the book, is the substance of symbolism. Because oftentimes you hear people, this is merely symbolic. This was merely symbolic. You could view it that way. You could say, well, it was merely symbolic. Symbols mean things to people. To quote Oliver Wendell Holmes Jr., we live by symbols. Miss Mary Hamilton. It's one of my favorite cases. And there are others in which people put it all on the line. And all of our lives are better because of it. Thanks for listening to me. Again, floor, objections. Yes.
Well, first of all, thank you very much, Professor Kennedy, for coming to speak to us today. My name is Kristen. I'm a 1L here at Tulane. I'm curious what your thoughts are on modern protest movements in the United States and how that impacts our law today. I'm asking because I think of the George Floyd protest, the protest in response to George Floyd's murder. That at the time in the summer of 2021, that's the largest civil rights movement in the history of the world. And it seems that what we gained from that was the opposite of what we wanted. I mean, by and large, across this nation, federal as well as state and municipal police budgets increased instead of decreased. And that's true on a macro level, as well as on like a city to city micro level. And so I'm curious as to what role you see those protests playing in our current legal and political situation.
Okay. Good question. And I'll take a stab at it. I think that the protests were impressive And I would differ with you. I think they have made a difference. I think people have to realize that changing the world is very difficult. And when I say, changing the world this much, I didn't say this much. I said this much. Very difficult. United States of America, 300 million people, takes up a huge landmass. You've got how many police departments? This wild and woolly and raggedy society of ours, it's wild. To change it this much, very difficult. And I think that the people, Black Lives Matter. And by the way, I have my problems, and I'll get to that in a minute. I have my problems with some of the, tactics and some of the language of Black Lives Matter. I'll say that Black Lives Matter put the problem of police brutality on the radar screen like nobody else has. They put it on the radar screen more than anybody else has. And see, I differ with it. I think it has made a difference. In the last 2 years, this is purely impressionistic, but you can check me on it. My impression is that in the last 2 years, there have been more acts of disciplining police than I remember ever in my life. Ever. It seems like, now, is it enough? No, not enough. But I tell you, in the last 2 years, I'll just be, in my car, driving home, listening to the radio, 2 police, discharged, fired, 3 police, indicted. Now, this isn't once, this isn't twice. I've heard, just over and over. Saying, dang. Now, of course, again, we have to test this out. I bet it's the case. Again, this is impressionistic. This is totally impressionistic. I don't want to make any, over claims here. I'd be willing to hypothesize, however, that because of the actions to discipline police, I would be willing to hypothesize that other police, knowing about this, seeing about this, hearing this, have changed their behavior. I bet it's the case that there are police who, at an earlier point in time would have taken an action, pop somebody up beside the head or something, who, nah, let's not do that. Now, again, is that all we need? No, of course, that's not all we need. But I'll take it. Now, the idea, progressive prosecutor. Now, there's a lot of controversy about that. The progressive prosecutors, you mentioned Chesa Boudin. You mentioned the progressive prosecutor in Philadelphia is about to get impeached. You had the Fox, the prosecutor in Baltimore. I think she's about to get indicted. It hasn't. I'm not saying that the world turned, but the idea of prosecutors acting with a different ethos, that is in part due to the George Floyd moment. At my law school, I can tell you, let me put it like this. With respect to the administration of criminal justice, when, people have debates and arguments, side of the debates, actually. Now, I don't view myself as I don't view myself as a conservative. And in fact, in the American ideological spectrum, I'm not conservative. I'm clearly a person on the left, but in these debates, actually, so for instance, I debate very strongly with, and I push back very hard, for instance, when, abolitionism, prison abolitionism. And I say, no, I'm not a prison abolitionist. And, we debate about it. In the aftermath of George Floyd, however, there are a bunch of people, including a bunch of my colleagues, who are on the other side. They have been moved to the other side because of Black Lives Matter. And, so is that going to make a difference? There are every year, there are going to be students who go through clinics, go through classes with a different consciousness than was the consciousness prior to the George Floyd moment. So, it's true that there's already been pushback. It's true that there's been backlash. It's true that some of the, enthusiasm, some of the hopes. I mean, there was a lot of stuff that was going on that was really quite sentimental. I mean, people thought, there's a demonstration, there are 250,000 people in the streets of New York. The revolution has come. 250, that's fine. There are 250,000 people in the streets of New York. There are a couple, however, at home who have a different view. So, there were some people who got overly, they overhyped the situation. Again, this is a big country. The powers of inertia. Forget about reaction, just inertia. Very strong. But, was there some change? And in my view, impressive change? Yeah. Really was. And it seems to me the activists, they get a salute from me. Again, now if we get in further and further and talking about things, they're going to think I'm sort of too buttoned down an old hat. But that's okay. We can talk. Others. Yes.
So from your perspective, the amount of positive change and progress that was made during this period of civil rights movement that you discussed, what do you think that was a result of? On a very vague level, was shift in American culture or the perception of people in power? Did everyone suddenly realize over time that racist and oppressive laws were wrong? Or was it just that the power of the oppressed reached such a height that those in power just had no choice? And there's still work to be made in terms of a culture that sees oppression as a means of running a society.
All of the above, all of what you said. There were many things that figured into this. Migration. One of the most important things that happened was, 6 million people left the South and went to the non-Southern United States, like my people. I told you, I was born in Columbia, South Carolina. I grew up in Washington, D.C. I asked my father once, Pop, why'd y'all move? My parents had just built a house. And why'd y'all move? My father said, well, we moved because I figured that if we did not move, one of two things was going to happen and neither was going to be good. Either a white man was going to kill me or I was going to kill a white man. That's why we moved. Well, I mean, moved. And when they moved to Washington, D.C., they moved to Philadelphia, they moved to Oakland, California, they moved to Los Angeles, they moved to Chicago, they moved to Cleveland, they moved to St. Louis. And when they moved, they put pressure on politicians. They hadn't forgotten Big Mama. They hadn't forgotten Auntie. And they said to their politicians, hey, we want you to do something to give a little bit of relief to Auntie back in South Carolina. And politicians, being politicians, responded. So Harry S. Truman, Harry S. Truman, really quite remarkable figure. I admire Harry S. Truman in many ways. A racist character. Now, Harry S. Truman was racist now. But he also was very good in many respects with respect to the civil rights issue. And one of the things that prompted him, he needed black votes. Harry S. Truman ran in 1948. His advisors said, you're not going to win unless black people really come out for you. That's what they told him, is that you don't have a chance. Dewey is going to beat you unless you can get you're going to need a bigger black vote than FDR got. So Harry Truman, well, okay, what do I do? He said, well, there's some things you can do. No president has ever addressed an annual meeting of the NAACP. Harry S. Truman did. Nobody running, none of the major party candidates running for president has ever addressed an audience in Harlem, in New York City. Harry S. Truman, well, get the car ready. The President's Committee on Civil Rights. People were complaining about the mistreatment of black soldiers in uniform and how they were black soldiers in uniform and after World War II were in danger if they wore their uniforms. And Harry S. Truman, who by the way was a veteran, this really did scandalize him. Personally, he was racist, but he thought this is terrible. You mean to tell me that black men in uniform are in danger? Yes. The case that really drove this home for Harry S. Truman was a South Carolina case, the blinding of Isaac Woodard. Black man on a bus, hauled off of a bus by a chief of police who gouged his eyes out. Harry S. Truman demanded that the Attorney General push a prosecution of the police officer, and he was prosecuted. A jury acquitted him within minutes, but he was prosecuted. Migration, very important. The Cold War, very important. After World War II, the United States is fighting with, the USSR for the hearts and minds of the newly, the decolonized or decolonizing new nation states in Asia and Africa, India, colored peoples. The USSR, the communists say, look, America talks a big game. America talks big. Oh yeah, they're in, freedom, justice, equality, Uncle Sam. Okay, go see the way that Uncle Sam is treating the black people. Take a trip to Mississippi and see what Uncle Sam will do for you. The United States State Department says, you know what? In India, all anybody is talking about is what the Communist Party and, the Soviets are saying. What do we say? Well, Take a look. In the briefs in Brown versus Board of Education, part of the Solicitor General's brief involves statements made by the United States State Department. We're being hurt by this. We gotta do something different. Because in the ideological propaganda war, international war, we're losing. That was important. Ideology matters. You know, the whole question of what's right, what's wrong, people's basic ideas of right and wrong. Philosophy. What do people think is just generally right? That mattered. That mattered. It mattered what law professors were saying in their classrooms. That mattered. And what they were pushing, you know, the ideas that they were pushing, what they thought was important. Ministers, there was a huge fight certainly within, you know, the churches. What is the position of the church on this? There was a huge fight about that. And then there were the dissidents themselves. I mean, and here, you know, again, I'm reporting on what I'm doing. Like I said, I've been at work on this, you know, book for 9 years. One of the things that makes this, for me, a real labor of love. One of the things I just find inspiring, I like it. Reading about people. Reading about people. I mean, Medgar Evers. I mean, my gosh. Medgar Evers was the field director of the NAACP in the early 1960s. Here's a man, he comes back, he was a veteran, he comes back, one of the first things that he tries to do is to vote. He does not succeed. A mob prevents him from voting. Becomes a civil rights activist. He works for the NAACP. By the way, Medgar Evers was going to apply to the University of Mississippi, but did not, because he took the job as field director for the NAACP. He has a wife. He has several little children. He put a bullseye on his back working for the NAACP. Goes all around Mississippi. All around Mississippi, fighting segregation. And in June, I think it was June 12th, 1963, John F. Kennedy had just given a speech, televised speech, announcing that he was going to send to the Congress civil rights legislation. It's the civil rights legislation that became the Civil Rights Act of 1964. He gives a speech. And soon after the speech is completed, Medgar Evers pulls into his house, driveway outside of his house, gets outside of his car, is clutching T-shirts. It said, "Down with segregation." And he's shot to death. And he dies with his wife and his children looking on as he bleeds out. Now, you know, what did it take to do that? I mean, you just think about it. Think about it. What did it take for a person with a young family to do as he did? There are academics who this is a real problem for in political science. I mean, this is a classic case of the collective action problem. How does one explain people doing things when they themselves will probably not be the direct beneficiaries of what they do? A lot of people have written articles and books about this. How does one explain this? I've read some of the literature on this. Tell you the truth, I haven't gotten a lot out of it. In class, when I talk about this issue, what I do is, I go through a little bit of the issues, some of the theories that people have propounded. I don't find them very satisfying. I don't find them persuasive. I say more persuasive to me is another source. And then I bring out my little boom box, and I play music. I play Mahalia Jackson singing How I Got Over. And I say, there's some things which it's not about strict, economic man or rational calculation. There's certain things which actually, it's hard to explain, but they are in the realm of, the spiritual. They're in the realm of, I don't know how, it's sort of, it pushes people to do things which are not entirely rational in a conventional, way of speaking. And I think that actually this helps to, for me, understand the heroism that was shown, and not just the heroism. And here I'm going to go back to your question about today, because here I really get into it with my students who think, with respect to the conduct of dissent, think that I'm too buttoned down. They say to me, and they say it nicely. They do. They say it very nicely. I don't, we butt heads, but it's a nice butting of heads. And they say, Professor Kennedy, they don't call me old, but this is what they're thinking. I know this is what they're thinking. And they, Professor Kennedy, you're all right with us, but you talking that old, respectability politics. I know what they're saying. And you know what? My response is, you're right. I certainly am. I certainly am. That's exactly the sort of politics that I'm talking about. Take a look at the way that Medgar Evers comported himself. Take a look at the way that Martin Luther King Jr. comported himself. Take a look at the way that John Lewis comported himself. And by the way, take a look at the way that Malcolm X comported himself. Do you think that they were unattentive to the way in which people viewed them? Their adversaries as well as their allies? No, they were not. Very savvy. They were very conscious of the way they were going to come across. And their leaders were too. So, the Freedom Rides. These were racial dissidents who got on buses in Washington, D.C. to come to right here. They were trying to get to New Orleans. A few of them made it after a long journey, not many, by the way, but a few of them did make it.
But they were trying, the idea was to get from Washington, DC to New Orleans on a Greyhound or Trailways bus and to test to see if in the South, local officials would abide by the Supreme Court rulings telling local officials you can't mess with people on interstate commerce. Congress of Racial Equality, James Farmer was the head. Said, we're going to test this out. We're going to have the freedom rides. Now, you know, you couldn't just jump up and be a freedom rider. No, it wasn't like that. You had to apply to be a freedom rider. You had to apply. You had to apply, and James Farmer would take a look at your application, and he had certain demands. He had certain demands. That's right. You had to wear certain things. You couldn't just go jump on the bus, you know, in your pajamas. No. James Farmer, he wanted people wearing he wanted people looking a certain way. He said that we have a script. If you are arrested, this is what you do. This is what you say. This is what you don't say. It was very scripted. And the idea was they knew that people were going to be arrested. And the idea was when you were arrested, because we know you're going to be arrested. When you are arrested, we want you to look a certain way in that photograph. Now, nowadays, see, what my students say is, oh, see, that was back then. And we understand back then because, you know, the folks wanted to, you know, sort of impress the white folks. No. They did want to impress the white folks, yes. They also wanted to impress their neighbors, their Black neighbors, their Black relatives. It wasn't just the white folks, it was the Black folks too. They wanted people to say, yep, that's my nephew. That's my niece. They wanted people to be comfortable with the way they looked and to be proud of the way they looked and the way they acted. I mentioned a moment ago, you know, in Columbia, South Carolina, the 187 students, the way they comported themselves. And I'm not going to filibuster, but I am going to tell one more story that I think, to me, it really drives this home. It's one of the greatest tributes I know of to the civil rights forces, and it was penned by a segregationist. James J. Kilpatrick. James J. Kilpatrick was he was the editorial director of the Richmond News Leader. He was a thoroughgoing segregationist. He was the guy, he was the brains behind interposition and nullification. He was the brains behind massive resistance. A thoroughgoing white supremacist, a thoroughgoing segregationist. One day he decides to go watch a sit-in. He said, oh, you know, I've been hearing about these, I want to go see one. So he goes to a sit-in and he writes about it. And he tells the following story. He says, you know, I wanted to go see a sit-in. I go to the sit-in. He says, I found it profoundly troubling. He said, I found it profoundly troubling because, and then he has a couple of paragraphs. He describes the Black students who are engaged in the sit-in. He says, you know, so there's a counter. And he says, I look, you know, and there's a Black girl who takes the first seat. And she's reading a biology book. And next to her is a Black boy, and he's reading Shakespeare. Then there's another one reading a geology book. And then there's another one reading algebra. And they're silent. They're reading their book. Totally disciplined. And then he says, and then some, you know, white youngsters come up T-shirts, pants sagging, have Confederate flags, says poor flag, grinning from ear to ear, and they pour ketchup and mustard all over the Black students. And James J. Kilpatrick says, I found this profoundly troubling. He says, the dissenters, the students, the Black students, much more impressive. Says, I'm a segregationist, but I mean, damn, there's no question. Black students were, much more impressive. There's something wrong here. Well, you asked me that question, what changes? There are people, I'm like James J. Kilpatrick. There are people who, that I'm not, I'm sure it took a long time. I'm not saying they were totally turned around by it. But something happened. And I think that there were all of these struggles. One other thing, very important part of my book is going to be about, lawyers. Lawyers were very important in this struggle. All sorts of lawyers participated. The lawyer, of course, I've made reference to Thurgood Marshall was the most well-known figure, and becomes a justice of the Supreme Court, and I talk a lot about Marshall. Marshall was very important, extraordinary person. I also talk about other lawyers. Who did some remarkable things. Some are not well known at all. One of the things I've done over the past, I'd say, actually over the course of this book, in my classes, I've said to students, students say, what would be a good subject? Because the requirement for the course was 20 to 30 page paper. So student, what would be a good subject? I said, listen, in every one of these cases, there's a lawyer. A lot of these lawyers, people don't know about these lawyers. Find out about these lawyers, write about the lawyers. And I've gotten some really excellent papers. One of my favorites, there was a lawyer by the name of R. Jess Brown. R. Jess Brown was in Mississippi in the early let's say 1961, in the state of Mississippi, there might have been maybe 4 Black attorneys who took civil rights cases. There weren't many Black attorneys, period. There might have been 10 in the entire state, but only 4 who took civil rights cases. R. Jess Brown was one of them. Now check this out. R. Jess Brown he was a school teacher. And he became a plaintiff in an equalization case. He was a plaintiff. He and some other Black school teachers said, well, this isn't right. We've got a certain amount of education, just like the white teachers have a certain amount of education, but the white teachers are being paid more than us. We think this is fundamentally unfair, even under segregation. Separate but equal. So they file a lawsuit. What does the state do? The state fires all the Black teachers to moot the case. So R. Jess Brown finds himself, he's out in the cold. He doesn't, what's he going to do? R. Jess Brown says, I got to do something here. R. Jess Brown was the local lawyer for James Meredith. And if you go to the Civil Rights Museum in Jackson, Mississippi, there's this really there is behind the case, they have a bench, and on the bench, they have the valise that R. Jess Brown has his initials on it. It's his lawyer's valise. And it also has his lunchbox. R.J. Brown. And then you have, you have, what about what about these white attorneys? There were white attorneys who they're just being attorneys. And then something happens that they can't live with. They can't live with. And they start taking up cases for the civil rights forces. And people say, you're a race traitor. What's wrong with you? It transforms their lives. There are a number of attorneys. There's a guy, Armand Durfner in South Carolina. He's worked at a very fine law firm, Washington, D.C., Covington and Burling. Totally blue chip place. Top of the line. Goes to Mississippi for a summer. Thought, this will be an interesting thing to do. Everybody expected, fine, he'll go and he'll come back. Nice thing to do. He goes, he's totally enthralled. He does not go back. He dedicates the rest of his life to civil rights, civil liberties work. And there are a bunch of people did that. And one of the things I try to do is, there were a bunch of left-wing lawyers. So on the good, the lawyers who've gotten the most attention, and they ought to have gotten the most attention because they were the leading lawyers, the lawyers for the NAACP Legal Defense Fund, great lawyers. Marshall, Carter, Constance Baker Motley, Jack Greenberg, Michael Meltzner, wonderful lawyers. But, for various reasons, including ideological reasons, left-wing lawyers have been, really quite minimized. William Kunstler was in Mississippi. People ought to remember that. There were left-wing lawyers also were part of the story, and their contributions need to be acknowledged. Question or objection? Yes.
Well, whatever the title, I look forward to reading the book. Is there any value in asking what the root of American racism is? And say, for instance, it's a convenient tool for those in the upper classes today in those positions. You can't hear me?
No, so is there a value in trying to determine what the root of American racism is?
Right. And if so, where are those theories being discussed?
I mean, yeah, I think it's a good question. I think, sure, it's a perfectly fine question to ask. My own sense, I think sometimes when questions like that are asked, people often, in my view, become too wedded to, a particular answer. I bet my sense is, there's probably a whole lot of different darn things that help to address that question. I mean, when you think about racism, I mean, such a broad, complicated thing. I bet that there are lots of things that are happening. I bet that religion is in that thing, part of the stew. Obviously, I think that, political economy, how do you rationalize making slaves of people? You know, that's a big deal. I mean, you know, that's an important thing. I mean, you know, it's, how do you rationalize that? You know, one way to rationalize it is, some people, you know, are, you know, natural slaves. You know, political economy, religion. I'm sure there, you know, I bet there are a bunch of different things. And, you know, I think it's a perfectly good thing. Now, I'll tell you, if I knew that I would be tested on your question tomorrow, I've got a book. It's an old book, but a very fine book. I've never seen it outdone. There's a guy named Winthrop Jordan who wrote a book many years ago called White Over Black. I think it was written in the 1960s, late 60s. I have never seen a book where that goes into that question more deeply. He begins, for instance, by talking about the view of Europeans when they go to Africa and the effect that has. He talks about Shakespeare. He talks about all sorts of things. He talks about, you know, the British encounter with Ireland and how that had effects on their racial beliefs. You know, he goes back into the, you know, 16th century and says, you know, there were lots of different things. Some contingent, just weird little things that, you know, actually turned out to have big effects. But I mean, if you're interested, I would say you can't go wrong reading Winthrop Jordan's White Over Black. It's a good, you know, it's a good subject. And, but you know, again, I think people sort of try to, you know, latch onto one thing. It's probably a lot of different things. Listen, before I leave, I just want to say, I want to go back to my very beginning, and I really want to thank you very much for inviting me here. Really, thank you very much for that. Just heartwarming. And I mean this. I'm not, you know, I mean this. I mean, I'm 68 years old now. There was a time when, you know, it seemed like things would go on forever. It's not like that, actually. Seriously, you know, there is a horizon. And I just want to say, for me, this has been a very meaningful moment in my life. I really appreciate it. If y'all have comments, if you have some suggestions for a more interesting title, let me know. And my last comment goes particularly to the students. Good luck. Best wishes. Keep pushing. Thank you.